Hello everybody, welcome to this video from Landmark Chambers in which we'll be covering the initial procedure for judicial review proceedings. My name's Smyth and I'm joined today by my colleague Charles Bishop, and we're going to cover the topics between us. So basically this is a very short introduction to how you begin a claim for judicial review, and we're just going to talk through the nuts and bolts and some practical tips as we go along. And there's lots of other talk where you can hear more about some of the things that we'll be talking about. So without any further ado, I'll start by talking briefly about the pre-action protocol for judicial review, and then Charles will talk briefly about starting a claim. So the pre-action protocol, you'll find it online. Just go to the MOJ website and there it is. And it's very clearly written, so you can read that for yourselves. Just a few points to draw out. First of all, what this requires is that the claimant writes a letter before claim to the proposed defendant. And it does give you a standard letter, but you don't have to stick to that letter. The main thing is to write a clear letter which sets out your grounds in summary form and hopefully puts them in a very strong way, so that the defendant is quaking, worrying about how they're going to defend your claim. And the pre-action protocol gives you various things that you need to include, but just some key ones to mention now. Obviously, you need to set out the matter which is being challenged, set out the issues in the claim, so the date and the details of the decision, or the act or omission, if it's an omission that you're challenging, set out the key facts, and obviously also set out why the defendant's decision is unlawful. And then importantly, tell the defendant what you want them to do to put things right. Also important to identify any interested parties. And if you're looking for information or documents, set those out in the letter. But something that I commonly see is that the letter sets out the request and then it doesn't explain to the defendant why those requests are considered to be necessary, and the defendant is likely simply to turn around and say, you haven't complied with the pre-action protocol because you haven't told us why it is that these requests are relevant and necessary. So bear in mind that bit of the pre-action protocol. And then obviously all the mechanics, your reference, address details and so on, the date for a reply, which is usually 14 days, but you can have a longer or a shorter time. And then the defendant replies, again, very important that the defendant grapples with things properly at this stage, so that the defendant's giving a full account of the decision-making process and the defendant's position. And in both cases, a really good pre-action letter or a really good pre-action response can really help your case going forward. Because JR is so front-loaded, particularly for a claimant, if you organise your thinking at an early stage, that will really help you as the claim goes on. If you send a disorganised or unclear pre-action letter, or if the defendant sends a very unclear pre-action reply, that's not going to do your case any favours. Just finally, a couple of things to say about pre-action. It's important, don't treat it as a tick box exercise for all the reasons that I've said, and the protocol is quite clear that failure to comply can result in cost sanctions. I'll leave that there and I will turn to Charles, who's going to talk about issuing.
So a claim for judicial review is started when the claim form N461 is filed with the Administrative Court Office in the High Court. Some cases start in the Upper Tribunal, Immigration and Asylum Chamber, but the majority of cases will be started in the High Court. There's a bundle that you will essentially be providing with the claim form, which sets out all of the details of your claim. The most important document apart from the claim form is a document called the Statement of Facts and Grounds. The Statement of Facts and Grounds is essentially an extension of the claim form. There is a section of the claim form which requires you to set out a statement of facts of your claim, and there's a separate section in the claim form which requires a statement of grounds. And the usual practice in almost every case is there'll be a separate, properly drafted document called the Statement of Facts and Grounds, often just called Grounds for judicial review. And in almost every case, those grounds will be drafted by counsel, by the barrister, with instructions and input and guidance from the solicitor. But generally, that is something that is drafted by counsel. Now, there's going to be a detailed session on drafting grounds for judicial review that our colleagues are going to be doing. So I'm not going to get into that in detail, but just some key points are these documents generally are supposed to be as concise as possible. There is generally a limit of 40 pages that you can apply for a longer page requirement if necessary, but generally they should be less than 40 pages. It's only in really complicated claims that you need 40 pages. Now, in addition to that document, you also need to provide all of your evidence in the bundle. Now that will vary hugely depending on the type of claim that you've got. Some cases will have very little by way of evidence because the issues might be all about law and they don't need to, claim doesn't need to go into a huge factual background. In other cases, you might have lots and lots of documentation. The most important thing is to ensure that all of that evidence is organized properly, that it's really carefully thought through whether the court actually needs to see that evidence at this stage, and whether it could be summarized in some way by way of a witness statement. There is no requirement to provide anything in particular, apart from you must provide a copy of the decision that you are challenging to the extent that such a decision is represented in a document that you can put before the court. There is detailed guidance as to how a bundle should be presented. The starting point really for considering how you should issue a claim for judicial reviews, something called the Administrative Court Judicial Review Guide. It gets updated pretty much every year. It's carefully reviewed by administrative court judges. It's really a Bible of judicial review practice and procedure. And in addition to that document, you should always check carefully the Ministry of Justice court website and also the judiciary website, which has various links to practice directions and practice guidance that gets issued by the courts at various stages. So, for example, during the coronavirus pandemic, there are regular iterations of guidance about how documents could be filed at court. But generally, the practice at the moment remains a digital process. And so bundles generally are provided in digital format as well as in hard copy. But you should always check what the current rules are on the website before preparing the claim. In addition, in the bundle, you need to include copies of any statutory material that's relevant to the claim. So that would be important if your case was about a piece of statutory interpretation. You say the defendant has got something wrong in the statute. And also you need to provide a list of essential documents for advance reading by the court. You could do that, and it generally is done in the statement of facts and grounds right at the top. The counsel will suggest what that is. The judicial review claim form also asks you to specify any other applications that you're making in addition to your claim for judicial review. And if you need to provide any evidence in support of those applications, so for example, anonymity, or for expedition or something like that, then you need to make sure you provide all those details with your claim as well. Very, very particular and important rules apply for what are called applications for urgent consideration. That's going to be dealt with by our colleagues in a separate section because the rules are really important. But basically that applies to claims where you're asking the court to make a decision within 7 days of filing the claim form. I think that is it in relation to issuing a claim. Is there anything you would add, Julia?
Nothing I would add there. Thank you very much for that, Charles.
Okay, so then we're now going to be moving on to the next stage, which is when the defendant gets a copy of the claim form and what they should do next.
So, what has to happen is that the defendant completes a form called an acknowledgement of service, and that will say whether the claim is being conceded or defended, or you can defend it in part. And as part of that form, summary grounds need to be completed. In a very simple case, they can be completed directly in the form, and in a more complex case, they will usually be drafted by counsel in a separate document. Our colleagues, again, will be talking about how to respond to a claim, so we won't get into detail with any of that, but just talk about a few bits and pieces. one of the main things for the defendant is to recognise that there is a very tight time frame for a response. It's usually 21 days, it may be shorter. It is possible to apply for an extension, but it won't always be granted. And in an urgent case, the defendant won't have 21 days to respond. So that partly shows why it's a good reason to engage well with the pre-action response, because then you're ready. That isn't always possible, but this is a really important stage, because this is your chance, if you're a defendant, to get across your key points in a clear and a crisp way, and also, if you can, to knock the claim out at the permission stage. So you're looking for knockout points at this stage. You're looking to keep it brief and clear, and basically present your best points as to why the claim isn't arguable, assuming that you're defending it. It's really important that the defendant takes the time to gather the necessary information so that it complies with its duty of candour at this stage. The defendant doesn't have to file evidence at this stage. In fact, that's really unusual, but in an appropriate case, there's nothing to stop the defendant doing that. And pretty much once that's all been put together, it goes in, and then there's a big long delay before a decision on permission, and that's what Charles is going to talk about next.
So judicial review is a two-stage procedure. The court needs to make a decision as to whether or not your claim should be granted permission to proceed to a full hearing. And essentially the court is asking whether or not the claim raises any grounds that are arguable. Generally, those decisions are made on the papers by a judge in the High Court, not always, but that's the general practice. And in most cases, we won't have asked for that decision to be expedited or taken on an urgent basis. And it will go into a long list of cases that need to be decided, which can take many months, depending on the complexity of the claim and the subject matter. Generally, you will get a decision and there will be an order attached to it. And that order, if it's granting permission, will set out some standard case management directions that set out how the claim should proceed thereafter. And that's going to be dealt with in later sessions. So, for example, the defendant has an opportunity to provide detailed grounds for resisting the claim, which can expand on the summary grounds that they will have provided that Julia has just explained, and also to provide further evidence. And there's normally provision for a reply by the claimant as well. If an order is made refusing the claim for judicial review, then the claimant has an opportunity to ask for a reconsideration of that decision at an oral hearing. That needs to be made shortly after the decision refusing permission. Generally, those permission renewal hearings last about 30 minutes. They're quite short and sweet, and the core points need to be thrashed out very quickly at an oral hearing. The defendant doesn't actually have to attend that hearing, but they often will. But the majority of the work is done by the claimant to argue why their claim is arguable. They have to provide renewal grounds when they apply for the reconsideration, and that those hearings are before a judge in the High Court, and normally the decision is taken at the end of that hearing as to whether or not permission is going to be granted. There are some cases where the court may order what's called a rolled up hearing, which is when they make a decision on permission as well as proceeding to the full substantive hearing at one hearing. So that's when the court considers it's not efficient to make, or for a variety of practical reasons, it makes sense to determine the permission question at the same time as hearing the substantive claim. I think that's it then in relation to permission. And then after that, the claim proceeds on the case management directions that would have been set out. If permission is refused at an oral reconsideration hearing, I should say, then there is the possibility of one further onward appeal to the Court of Appeal, but as you would imagine, the chances of succeeding at that stage are even less.
Thank you, Charles. And one point to mention in relation to costs is the defendant can, in their acknowledgement of service, apply for their costs on the acknowledgement of service, but they won't usually get the costs of turning up to a hearing. but it's often very sensible to do that. It will only be in exceptional cases that the defendant will get their costs turning up to the hearing. And that really is our whistle-stop tour of the initial judicial review procedure. Thank you very much, Charles, and thanks all of you for watching us. Please look out for the next in the series from Landmark Chambers, and please do contact our practice management team if you have any questions or you would like to speak to either of us. Thank you.
Thank you.